Okay, tonight we're going to go into some of the basics of filing a case as a pro se litigant. Now, what a pro se litigant is just a fancy word that the court uses for somebody that represents themselves directly in court. You don't need a lawyer to represent you in court, particularly if it's for something like this where no money is going to come from the case. You're just doing it in the public interest. You want uh, you want your voice to be heard more than anything, um, and taking on a lawyer is gonna introduce a money component into the case that's just going to distort the complexity of the case. Uh, for a simple case of basically being the squeaky wheel in court, uh, my view is pro se is the correct strategy because you're really doing it in your interest as a citizen, and uh, you want to address matters that are just for governance, um, which is not a money case. Um, anyway, so there's a few basics you need to know when filing a case in the district court in Washington D.C. The first version of the case is always paper, um, meaning that you're going to have to print out, fill out the forms, print them out, and sign your name at the bottom. That's called a wet signature. Um, and it doesn't necessarily have to be with pen, but the rules say that. But it can, like it can be a picture of your signature printed out. That's generally fine too. Um, these cases are pretty simple to file. First of all, there's several forms that you're going to need to fill out. One is the the civil cover sheet. Civil cover sheet, uh, which you can find on the U.S. District Court for Washington D.C.'s website, which I'm going to put below, a link to below. But it basically, lays out who the plaintiffs are. Plaintiff is that's you, Joe Alter, pro se. Your address, the defendant, the attorneys, attorneys of record. In your case, it's you. It's a pro se plaintiff with your address, telephone number, and email. The basis of jurisdiction, uh, where you have to check a box for. In my case, it's a U.S. government defendant. So, because I chose to sue Donald Trump as the U.S. president, because for Alter v. Trump, signing the the petition uh, could be construed as something that he does. Signing the pardon could be construed as something that he does uh, within his duties of office. I would dispute that. Frankly, corrupt pardon, isn't valid regardless. But we're not disputing the validity of the pardon. We're sidestepping that, and we're making the allegation that um, that that signing that corrupt pardon in the circumstances that he signed it with was a violation of the 14th Amendment, Section 3, which is the insurrection clause. Um, anyway, we're, to be safe, I'm suing him in his professional capacity. Um, and the other box that you need to check on that basis of jurisdiction is that it's a federal question. The federal question is, given this set of circumstances and everything that we know, factually, not inferred, but know, such as the fact that 6 people were convicted of seditious conspiracy, all said that they did it for him, uh, in court in their criminal trials under oath. Uh, So, and we know the circumstances name is intricately intertwined with, you know, with the but for Donald Trump, none of this would have happened. Um, so the federal question is Donald Trump has Donald Trump overstepped his office into the realm of 14 Section 3? And that is a question, a direct question of circumstances against a constitutional amendment. Um, the other box, other stuff you need to check off is, in my case, there's nature of the suit, checked off constitutionality of, uh, of statutory actions, which is 890. And origin is original proceeding. This meaning that this is the original case. This is not a continuation of some other case. Um, and then the you have the cause of action. In this case, the cause of action was his executive order demanding the parole and release of January 6th participants. Um, the What's requested in the complaint uh, is left blank because uh, it's not a class action suit. As a pro se litigant, you cannot represent a class. Uh, I mean, you could fight for that, but it's generally not accepted in the courts anymore. I'm not demanding any money, so I put NA. Jury demand. In this case, I believe I checked yes. But that would only happen once the judge decides to let the case go on with the merits. Until then, uh, through all the standing briefing, it's really the judge that you're interacting with, or the clerks, basically, and briefing back and forth, if they permit you to do that. And related cases, if any, you want to put a list. In my case, I put a few of the January 6 cases in my list, and then you have to sign it as and date it as the attorney of record. And that's about all you'll have to do on that form. Then there is the once again, that was the civil cover sheet JS44, and I labeled it Alter v. Trump. The other thing that you need to do is, for each of the defendants, in this case it's just Donald Trump, you need to fill out a form called an AO 440, which is a summons that has to be delivered to him that will alert him that he's been sued, and it has to include all the forms that you initially sent in, plus a copy, plus 3 copies, I believe, of wet copies of your lawsuit, uh, and that basically just you know says the defendant's name, you know, Joe Alter versus Donald, President of the United States, Donald Trump, and the defendant's name and address, uh, and the and I I'm trying to remember whether I sent that one to the White House or to Mar-a-Lago. In any case, you'll just figure it out based on who your defendant is. Uh, and basically, what it says is a lawsuit's been filed against you within 60 days after service. The United States Attorney, you must serve the plaintiff. Uh, Answer attached, blah, 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 blah. It's all on the form that you can get off of the website. And that goes to the clerk of the court with all of your other case initiation papers. And what you want to get back from that is a copy of that that's been stamped by the clerk, said it was filed on such and such date, has this clerk's signature. That basically means, that the filing is at least kosher on first inspection, and that's your. You can't send that that summons to the defendant until you get that stamped by the court. So you need to wait for that stamped copy, and uh, depending on how you set it up, that'll either be posted online on the docket, emailed to you, uh, or sent as a paper copy. Now, if you just want things sent to you as a paper copy, there's nothing else to set up. But if you want, if you do want to continue forward using a web account, uh, I mean, what I'd recommend is setting up a Pacer account, but that's a whole other thing that maybe you don't want to do. But I find it convenient because it allows you electronic access to any of the court events on the docket. The docket is where each event is listed basically as a hyperlink. Um, and in order to get that, you'll have to fill out an ECF attestation that basically attests that you've done the online tutorial for how to use ECF, and that you have a computer with a good connection, and you regularly check your email, and you understand that you must monitor ECF and comply with federal rules. Um, and this is basically a legal document that you're submitting to the court. It's not a form so much, but you can get a template for it from the court's website under pro se documents. Now another detail to note is that unless you're imprisoned, that there's two different types of pro se. Unless you're imprisoned or dirt poor, can't pay a dime for the loss for the even the filing fee. Uh, you don't want to check the indigent box. It makes all that stuff free, and there's a few convenient things with the U.S. Marshal that you get out of that. But uh, I prefer not to because it just complicates my relationship with the court because uh, uh, you have to give them all your financial records and all kinds of crazy stuff that you just don't want to deal with. And I wouldn't qualify for it anyway, just based on assets. Um, so so that's about it. Uh, now, so you have to fill those forms out and do your initial complaint. Now, your initial complaint is important. Uh, something that I learned the hard way is that ECF, which is the online docket, is is not like a cloud account. You can't just whoops, I made a mistake. Upload a new one and delete the old one. Everything that goes into the docket uh, is stays there. Uh, you'd have to file a motion with the court to delete it, and they're not going to do it. They're going to want to, like I said, the judge wants to dispose of your case. So uh, one of the things they'll usually hit a pro se litigant with is posting lots of versions to the docket, even though you only want them to read the last one. Don't do that. It really is the lowest hanging fruit for a judge to throw your case out. When you post a document, it should be the only version, and that's becomes particularly important for your original complaint because once you revise a complaint, you get two shots at writing a complaint. So, for instance, if you write a complaint uh, and the court hands back defects on the complaint or makes legal arguments against, say, standing or whatever, you might want to strengthen those things in the complaint or fix those things. You've only got one chance to do it. After that chance, uh, they can dismiss sua sponte. But the sua sponte is a word for without even hearing anything further, um, and you really want to avoid that because that lives in your record, and the next time you file a case, they're gonna see that you've had stuff sua sponte dismissed, and there's really legally there's nothing wrong with that. But it's not a good look. So you want to avoid it. Um, so uh, when you file your original complaint, uh, what you want to be extra careful about is what you ask for in terms of a remedy in the case. Now, in the cases that I ended up filing, uh, the remedy is always declaratory under the Declaratory Judgment Act, and I don't ask for any financial remuneration. Uh, and those are important because there's a lower threshold uh, under the law where the court can very easily get the impression that you're trying to take advantage of the system for some kind of personal gain, and avoiding that can go a long way to to raising that suspicion. And if you're really not after a payday, don't ask for one. Um, and the other thing you want to avoid when asking for a remedy is the court, particularly if you're suing the executive branch, the court can't tell the executive branch or Congress, uh, or has to be very careful about telling them what to do because they have a very narrow band of things that they're allowed to order from those defendants. And if you do try to tell them something, ask for something that's going to change policy, make a demand that they drop a certain policy, uh, that's that's where separation of powers comes in, and you can argue about that with the defendant for a long time before you get to even talk about the merits. So don't do that. Really, under the Declaratory Judgment Act, just the judge saying what happened and whether it was illegal, those are a big win, and settle for that. Uh, it's going to make your case go a lot faster. And civil cases can't prosecute somebody criminally, so you don't cite any criminal statutes unless you just want to make reference to them. Uh, that you know you can file a case under a criminal statute, but you need to be clear that you're not asking for punishment. Um, so those are the big do's and don'ts. Now there are a lot of AI systems that will be very helpful in discussing your case with you, and what sort of parameters you want to start off with originally, what sort of counts you want to name, what uh, cause of action, and uh, you need to have some facts of standing that explain how the case affects you directly. Now, they prefer things like, I'm missing a leg, and this cost me $1 million because I had to move, and blah 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 blah. But you know that's really not the type of claims we're making, because the harm that you receive as a citizen are things that are done to you, in my case, as the result of illegal executive orders, a pattern of executive orders that he's issued that are totally unconstitutional, and they've affected you or your family members in some sort of adverse way. Like in my case, I had in the last Trump administration, at the end of the last Trump administration, just before was it before the insurrection? Yeah, it was just before the insurrection. Um, I was emigrating back from France with my wife, and we realized at the last moment that she had an expired visa, and just to be on the safe side, we stopped by the embassy, and they got really aggressive with us. They said, "No, she can't go." And I was like, "What? We've been married for 23 years. Are you kidding me? I just bought a house." Uh, and the thing is that Trump's order had no exceptions, so there was no way around it. So I had to go with the kids, and I was hoping that this would get worked out in a couple of months, and she would join us. It took over a year, and my kids were teenagers at the time, and uh, it was terrible. it really put a strain on our family. My daughter tried to commit suicide. They basically removed their mother from our family for a year, and left this whole uncertain future and just fear of government reprisals. And it was really a terrible time. I didn't make a huge deal about that, but along with my complaint, I filled out a an attestation that was it is basically a sworn statement of, look, this doesn't directly connect to the executive order of the pardon, but it connects to a pattern of illegal executive orders that are seditious in nature, and that are capricious, and uh, you know unlawful. And in fact, that order, the zero exceptions order that he had made, was later ruled unlawful, after she had already been permitted to enter under the Biden administration. Um, so so as I saw it, that was sort of my main hook in terms of standing. But there was also, my younger daughter was in an IEP program because she was diagnosed with autism. That had a lot of funding yanked from it by another illegal order about Doge, uh, and you know uh, uh, both of my kids were LGBTQ at the time. One of them sort of done with that. At least she's living with a very very nice guy. She's 21 now, but my younger daughter definitely is. And I felt that, like, what these kids had to live under was just totally unacceptable. The environment that he created through these predatory executive orders. Now the court really didn't buy my argument of standing, um, in my case, because it was too unrelated to the pardons. I don't really agree with that, and I also don't agree that I really needed any kind of special standing for a structural case about a pattern of violation of Constitution, and association with seditious conspirators. Um, but that was what the district court found. But you know, you should at least have some connection to the case, because under Article 3 you need to have some connection to the case, because uh, the court wants to know that you're not uh, taking on the case to take a dive. For we've seen this in a lot of cases where an interested party will take on the case, and they'll just do a terrible job on the case because they want to lose the case, and it ends up being a collusive relationship between, you have a DOJ that wants to win the case for some political agenda, and somebody that wants to help them out by losing the case. Uh, that's what the court is trying to eliminate when it asks for standing. Uh, you have to have some connection to it. Like, you're deprived of lawful governance. That's probably the weakest one, because the Supreme Court has ruled a number of times against diffuse harms. Now, there are other diffuse harms, are harms that are done to everybody. You need to have some unique harm, way that it harms you, in order to have traditional standing. And the case that most frequently gets invoked for that is Lujan versus Defenders of Wildlife. This is an important case. However, it has limitations, and I'd just like to talk a little bit about what I see as limitations that 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 you can fight for if they don't accept your standing. Uh, for example, structural claims. There are a number of cases like Super Tire that say, a citizen can file a case structural claim case that the government has violated your civil rights, There's another one. I'll come back to it later when I'm talking about structure of the case. But there's another one called Lexmark that's also about structural claims that don't impact personal interests. Um, he doesn't require a personal tragedy. And another one that's about somebody who got convicted for attempted murder in a state case, and it intersected with a federal statute, and they claimed a 10th Amendment violation. I can't remember the name of that case offhand, but I'll come back to it. Um, so those are an important defense for why you have standing. Uh, but also, there's an Office of Legal Counsel memo that I found out um, as I was putting the case together that discusses presidential immunity. Um, that uh, the, before there was such thing as presidential immunity, uh, there was a 1973 Office of Legal Counsel memo that Nixon had his Office of Legal Counsel draft up the memo saying, well, you can't really sue the president because he's a busy guy, and you should take that up. You should take that up with him afterwards. And uh, and I believe that kept Nixon at least kept the courts kind of busy with that question while the impeachment was going on, and then eventually made a deal with Congress that he would leave peacefully and they would drop all this stuff. Um, but but the council the OLC memo remained. There was never really another occasion until Clinton where the question of prosecuting a sitting president came up, but the memo was was about the non-prosecution of a sitting president, and it was written by a lawyer at the time named Randolph Moss, who later became a federal court judge in the D.C. district. Um, and uh, sorry, that's the second version of the memo that came up after Clinton that examined. Well, what about for like private conduct, like what happened with Monica Lewinsky? Surely you could indict the sitting president for you know conduct that has nothing to do with being the president. Um, and the second draft of that Moss wrote of the Office of Legal Counsel memo was yes, absolutely you can. That's private conduct. However, if it's in any ways associated with the job of the presidency, um, then you really can't. Um, or at least we don't want the DOJ to be filing those kinds of charges because it's going to cause political mayhem. At least that's the concept. Uh, in both cases, that memo is very self-serving and written for the benefit of a president who's broken all kinds of laws. Nixon and then Clinton, um, and later Bush as well endorsed that memo and others. Um, and in fact, I think Moss wrote it during the Bush presidency, at the beginning of the Bush presidency, after 9/11, shortly after 9/11. So basically, it lets the concept is to let the president do things that are legally in the gray area without the the DOJ pouncing on him every time. Uh, I I don't really buy it, but it exists, and to this day it prevents the DOJ from bringing criminal charges against any president, and it just gets stronger every time they revisit it in terms of how much it's accepted as tradition. Like even Robert Mueller never filed the case, even though he absolutely did not exonerate Trump in his first term for the election interference that he participated in. But he couldn't charge him because he was still a sitting president, and that case was just that investigation was disposed of before Trump left office. Um, and that really sort of shut that whole thing down. It's really quite shameful. But in any case, uh, those are the basics for setting up your case that you're going to file by mail. Now, uh, the way you want to file a wet copy by mail and serve the summons when you get it back from the court is by first class mail. First class is usually accepted. You can usually send it first class mail to, I think in my case, I sent it for a case against a federal employee. You have to send it to the DC U.S. Attorney, as well as the Attorney General, the DOJ, so that they can be alerted of a case against the president. That's a requirement in filing the case, and I believe they have to be named as defendants, but I'm not sure. I can't remember that offhand. That was like a year ago. But that's the initial process of filing a case. So you file that, and you have to drop a, a corporate check. And luckily, I had a corporation that I could make a corporate check out. They won't accept a personal check, and I don't think they'll even accept a certified check. So if you've got a friend that has a corporation that'll write out the check for $500, just drop that in the envelope, and then go to the post office and send it by first class mail. And you want you want to get a return receipt, meaning the recipient signs that they've received the envelope. Now, some defendants are going to try to dodge service. We're not there yet, so I'm not going to talk about that. But certainly the DOJ is going to sign the receipt, and the U.S. Attorney will sign the receipt, and that's really about all, that, and the shipping receipt is all you need for to 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 for the courts to accept, that you've properly. Oh, we're not talking about service yet. Sorry, back up. Initially, you only need to send it to the court. Um, you're not serving a summons until you get those summons stamped by the court. Uh, but you want to send it, return receipt, first class mail. That's a legal confirmation that they've received it on such and such date. And you don't technically need to do that, but it's standard. They expect it to be sent to them first class mail. And what will happen is that it'll take about a week to a week and a half to have a case initiated. And if it is initiated, what they'll do is they'll assign it a case number, and sometimes right away a judge as well is selected for the case. And what they'll do is they'll send you back a stamped copy of your case, and also it's got a stamp on it with the file number for the case. And the file number is usually the year, like 25 dash, and some 4-digit number, and then the 3 initials of the judge. And that's your case number. That's what you'll refer to in future communications with the court. So that's basically setting up a case. Now I'm going to put some links down below for where you can find the pro se tutorials at the about ECF and stuff like that at the U.S. District Court for Washington, D.C. But once you've got a case number, you're in business. And it doesn't take that long. It just takes about a week and a half. Thanks. Well, the next segment will go over summons and service.